What's up, viewers, subscribers, and agents alike? It's your boy Enlightend Luciferian Prince coming at y'all once again. Welcome. If this is your first time viewing my channel, please hit the like, subscribe, and make sure you hit all notifications. That way, whenever I post a video, you will be notified. Also, you can catch me at Allonge number 7 on TikTok. I'll leave it in the video description. It is what it is. If you watch this video around children, you already know the drill. Y'all know the drill. This is not for children. Okay? So let's just keep it that way. In lieu of my videos, and I'm trying to put out as much content as I can. If I don't get in touch with you after, saying a certain period of time, don't feel bad. Me and my wife, we're about to officially get married. So I'm worried about that. You know what I'm saying? So with that being said, that's why I'll be busy. All right. So with that being said, I was telling people about the mortgage situation, and I'm going to give it to you. The title is called Mortgage in a Nutshell. Okay. Over the few videos I've done in the past, it's saying particularly a mortgage is a contract. And I was breaking it down to people saying particularly that your security was your signature. We already got that part, right? But they finesse you because they put a promissory note in there. So basically they're saying that they placed a lien on it because they have an interest in it. So we got that part, right? So a lot of people ask the mortgage company particularly, for the title or deed, I should say. They're never going to give it to you because 9 times out of 10, they done probably already sold it. What you have to do is ask for an Allonge, Allongene. So when you do this, you ask them for this particular, and you have to ask them also for a bill of particulars, but we'll get there later. And Allonge is this. Look up the legal definition, pull up the war machine, so that way we don't get this misconstrued. And I tell people that the reason why you have to do this is because, that gives you particularly a bill of particulars, this is it. Okay. An Allonge, which is an Allonge note, is a document that is attached to a note or other negotiable instrument, such as a promissory note, to the bill of exchange to transfer to a third party or bearer. It can also be used to receive additional endorsements where there isn't enough space on the note itself. An endorsement written on the Allonge is considered to be written on the note. This is what you need to start asking mortgage companies for. If you don't ask for this, you'll never see it. You see what I'm saying? And the reason why people don't understand that this is a document that's attached to a promissory note is because it gives you a direct bill of particulars. So I'm going to read it again. A document attached to a promissory note or other negotiable instrument containing an endorsement that transfers the note or negotiable instrument over to the third party or bearer. The Allonge must be firmly affixed to the note. So when you ask for the Allonge, you also supposed to have the note as well. Do you understand what I'm saying? So let's not get into no argumentative state with these individuals. Let us ask for the Allonge. The Allonge must be firmly affixed to the note. An Allonge is typically delivered to a successor lender when a loan is assigned. I'm going to say it again. An Allonge is typically delivered to a successor lender when a loan is assigned. So that means if it's firmly affixed and you ask for the Allonge, you get the note. That's what you need to ask for. Now the deed, you need the Allonge. You need the note. It's firmly affixed to it. Do you get what I'm saying? Don't be afraid to ask these people for this. You know what I'm saying? You have the right for full disclosure. Okay? Full disclosure is imperative. So when you ask them for that, they must give it to you. Now, in rim of that, you basically say, well, if you don't give it to me within 7 to 10 days, I'm going to go through a judicial process and I'm going to go ahead and go through discovery. Not a lawsuit. I'm just going to go ahead and ask the federal court, by order, the federal court, for you to give it to me. Because your signature, anything you put your signature firmly affixed to, you have the right of full disclosure. Don't let these people try to scare you and talk about they don't know what they're talking about. I just read the definition. And you need to read the definition to them just in case they think you're a fool. You see what I'm saying? In case they think you're a fool. And allonge, again, is a slip of paper affixed to a negotiable instrument, such as a bill of exchange. But remember what I said, an allonge is typically delivered to the successor lender when a loan is assigned. So that's giving you what is called a bill of particulars. Here we go. Give me a second. All right. Here we go. Now, legal process. Hold on, wait 1 second. And this also works in child support cases too. A bill of particulars is a formal written statement that details claims or charges in a legal action. It can be used both in civil, told you, litigation and criminal defense. In some situations, the defendant can request for a bill of particulars from the plaintiff to clarify the details of their claims. For example, in criminal cases, a bill of particulars can give the accused notice of the factual basis of the charges, such as it is since I told you could use it civil too. For you people facing child support, bill of particulars, okay? Before you pay another dollar for any type of proceeding, I need a bill of particulars. That's what you ask the judge for. Now, it says that can help ensure that all necessary elements are covered before trial so that the judge doesn't dismiss the claim. So basically, you are asserting your right to full disclosure. Now, I know it seems like I'm going all over the place from civil. It's all civil, y'all. It's all civil. Whether people want to believe it or not, it really is. And when you ask for the allonge in a mortgage situation, or you ask for a bill of particulars in a civil situation, they're one and of the same. See what I'm saying? It's just that legally defined, they're different. But mortgage people who are facing individual situations such as foreclosure and stuff, give me the allonge, which means that you become now the bearer, which is the holder in due course. See what I'm saying? So when you have that in your possession, all foreclosure proceedings must cease and desist. Then I also told people about the creditor disclosure statement. The beautiful thing about this is when you have a proceeding, if it hasn't went through foreclosure, if it hasn't even went there yet, what y'all supposed to do, don't sit on your ass and wait and just think that it's just going to melt away. What y'all need to do is contact these people first via phone. Because remember, all phone calls will be used as evidence if it goes forward. You have to state your voice, state your claim. Say, according to Fair Debt Collection Practices Act 1692, 1694, I'm going to send you, notice what you're saying, I'm going to send you a creditor disclosure statement. Please attach all documents related to the statement of this debt that you say that I owe. I'm going to send it to you, certified mail return receipt. That means it's a cease and desist. That means they have to stop any collection efforts until they fill out that form. Here's the beautiful thing. They never do. Headlock. So how can foreclosure proceedings proceed against you if they were to do it? Guess what you have? You have what's called your proofs of claim. You have your cover letter and you have your creditor disclosure statement. If they don't send you back the creditor disclosure statement within that time allotted, you send them a notice of default. Those three things, I tell you right now, the judge will never rule against you. And you just learned that in less than 10 minutes. No cut, no chasing. Straight up. No cut, no chasing. No cut, no chasing. I put these people on the run. Telling you, put them on the run. See, y'all have to start documenting stuff. This is why people lose in court. Don't be afraid to call on people. Blow their phone up. Don't they blow your phone up? Blow their phone up. And tell them, cease and desist all collection efforts until you fulfill the desire that I sent to you via mail certified return receipt and send it back to me signed. Okay? Send it back to me signed. This is what you need to tell these people. Give me a second. I said this time and time again, but I have to say it again for the people that's new to the channel. Welcome. And agent, fuck you. But this is the truth. This is what the creditor disclosure statement has to say. Okay? Name and address of collector, which is called the assignee. Name and address of debtor, which can't be you. Account numbers. That means all accounts taken into account for loans and whatever the case may be. What are the terms of assignment for this account? You may attach a fax of any records relating to such terms. Have any insurance claims been made by any creditor or assignee regarding this account? They have to answer in the affirmative, yes or no. Has the purported balance of this account been used in any tax deduction claims? They have to answer in the affirmative, yes or no. Please list the particular, remember what I told you, products or services sold by the collector to the debtor in the dollar amount of each. This is where they fuck up because they didn't claim it on taxes. I'm telling you right now, this is a very powerful weapon. Upon failure or refusal of collector to validate this collection action, collector agrees, but they don't respond, they agree, to waive all claims against the debtor, named herein, and pay debtor for all costs and attorney fees involved in defending this action. Authorized signature for collector and the date. Please return this form completed and attach all assignment or other transfer agreements that will establish your right to collect this debt. Your claim cannot be considered if any portion of this form is not completed and returned with the required documents. This is a request for validation made pursuant to Fair Debt Collection Practices Act, which is the entire section. If you do not respond as required by this law, your claim will not be considered and you may be liable for damages for continued collection efforts. Please allow 30 days for processing at the receipt of your request. So people, again I say, don't feel obligated. Ask questions. Just because they send you a statement doesn't mean that you have to pay. It is your right, it is your duty as a consumer to inquire about a debt that people say you owe. It's your duty. Fuck a right. It's your duty, your due diligence. But a lot of people won't hear me though. But some will. You see what I'm saying? Some will. I done had many successes with this. You see what I'm saying? Because I know how to put these people in such a tight space where they don't have no wiggle room. See what I'm saying? When they don't have no wiggle room, they can't proceed legally until they fulfill what is required. If they were to take you to court and you was to send all those documents before a judge and say, well, I sent it to them. They saying I'm in deficit of paying, but I asked them to prove it. I sent it to them on multiple occasions. Certified mail return receipt. That way they can't say they didn't get it. The judge is gonna look at them and say, what happened? But remember, don't be naive. Judges work for these people too. All courts are banks. Don't get it fucked up, people. Don't get it fucked up. All courts are banks. I don't care which, federal, state, superior, criminal, it doesn't matter. They're all banks. They all keep what's called accounts receivables. Don't get it fucked up. But it's your duty to make sure that you don't owe anybody anything. And if they don't respond, their claim cannot be valid. So that means that they can proceed against you in foreclosure, but you have the ability to state on record they failed to state a claim upon which relief can be granted. Real talk. Bismillah. I'm just saying. I'm just saying. No one can come against you in a court of law without evidence. If you don't respond, that's a tacit admission that you still owe them people. See, arbitration is nothing more than them actually trying to recontract you. Recontract you. We're going to renegotiate terms and conditions. Don't ever give them that. No, I don't want arbitration. I want you to respond to this correspondence. All it is 2 pages. You ain't got to send them a whole book. Keep sending them that letter. Keep it in your computer, in your file, and just change the date. As months go on, every month you send it back to them. Every month you send it back to them. Every month you send it back to them. They can't never foreclose because they never respond. So if they do get tired and be like, you know what? Let's just go with it. Good. I got as much evidence as I need to whoop your ass in court. You're welcome. By the time you go to court, you should have something like this. Send them a copy and you keep your copy. But I ain't no lawyer. I just like to read. Anybody that needs help with this, my email is in the video description, describing the video. Consultations, it is what it is. Serious inquiries only. I told you, I'm planning my wedding. I don't have time to waste. Okay? So, it is what it is, people. Get in contact with me as soon as possible because the clock's ticking for me. I got plans. So, I'll say again, peace, light, love. Y'all take care.